Um, what we're doing today is looking at 5 procurement law cases from the last year or so to see what we can learn from them. And just while everyone's joining, a few introductions. So I'm Jenny Beresford-Jones. I'm a senior legal advisor and procurement specialist here. And I'm here with Shailee Howard, who I'm sure many of you will know already, and also our new colleague, Victoria Armitage, who has joined us as a procurement specialist from the Government Legal Department. And her last job involved drafting some of the procurement bills. So we're really excited to have Victoria with us. Just having a look at the procurement bill while everybody's joining. The latest news on that is that the bill has finished in the Commons and has gone back to the Lords for the Lords to consider the amendments made. And we recently had an announcement from government that they're looking at a go-live date of October 2024, and also the first of 2 consultations on secondary legislation that underpins the bill is now underway, and my colleague Victoria, who's with us today, has drafted some of that legislation. So it's really interesting for us to see what the responses to that consultation look like. Before we get started, just a reminder that you can find recordings of all of our past 5 in 25 webinars on our procurement portal, together with all the questions and answers that were asked in those. So that's a real mine of information that you could have a look at. And also a bit of a plug for our procurement blog. We update that regularly, and you can sign up for alerts so that you never miss a post that we've written. Just a little bit of housekeeping, and we are recording the session, and that will be available afterwards together with the slides. As usual, please do put any legal questions in the Q&A. We won't be dealing with those live in the session so that you can all get on with your day at 10:30. But as we usually do with these sessions, what we'll do is put together a Q&A document and try to address those questions. And that will come around with the recording and with the slides. And also, finally, right at the end, I think a feedback form should pop up. Really grateful if you could spend a minute or 2 just completing that, because it helps us to tailor our future webinars. And I think sort of going forward from September, this series will continue, and we'll be sort of shining a light on the procurement bill. Once it's finalised and we have a good sense of where we're going with it, we'll have a series of sessions on the bill to help us all get up to speed with what's changing. So I think in terms of an introduction, that was what I was going to say. And I think I can hand over to Shailee, who's going to look at our first case, which is Bromcom Computers. And this is all to do with evaluation and scoring tenders. Thank you, Shailee.
Thanks, Jenny. Good morning, everyone. It's nice to see so many of you join us this morning. I'm going to start by talking about the case of Bromcom. There's lots to be learnt from this case, but I wanted to focus specifically on the moderation process and the evaluation process. This is something that we get asked by our clients all the time. It's a very common question around sort of the act of evaluating and moderating and what that means for the risk profile of your procurement. We have supported clients sort of during the evaluation process when they're planning the moderation, and also sort of on the more contentious side, so acting for authorities and for unsuccessful bidders who are wanting to sort of look a bit more closely at the award decision and think about the way in which the score was arrived at. So just briefly pausing on the facts of the case. So the claimant, Bromcom, which is a fantastic name for a company, I think, it sort of rolls off the tongue, they brought a claim against United Learning Trust, which is an education charity. The contract was for specialist software to be used in sort of 57 of its schools. It was a competitive dialogue procedure for a 5-year contract, and the value was around £2 million. The contract was awarded to another supplier called Arbor, who won by a very narrow margin. There were lots of allegations of breach of the procurement rules in this case. I am going to focus on the moderation process, but there were also issues around incumbent advantage. So in that case, the incumbent had offered a discount on existing contracts, which the judge said was unfair and not allowed. The form of submission as well was an issue. So the authority used Dropbox. Other repositories are available, I should say, but that effectively the system did allow bidders to sort of, potentially update, amend, upload their bids after the event, which the judge also said wasn't in compliance with the rules around electronic portals. And there were also sort of manifest errors found in the evaluation process. So the key takeaway from this, if we just move on to the next slide, please. The key takeaway was that the evaluation methodology was not correctly applied, and that led to the finding of manifest errors. And I think the next question focuses more on manifest errors, so I won't talk too much about that. But the way in which the final score was awarded was by taking the scores of the individual evaluators and averaging them. And that was all done before the moderation process. The ITT itself said that responses would be scored between a 0 and a 5. There was no it wasn't contemplated that decimal points, etc., were going to be used. And the court said, well, that's not a substitute for a proper moderation process. I've popped a quote on the slide for this particular on this particular point. What the judge said is that there needs to be sort of a sufficient discussion of the evaluator's particular points in the moderation exercise. Averaging is nothing more than a mathematical exercise. What the process of moderation contemplates is a give and take, a discussion to reach a collective consensus. So at the end of that, the authority has a reasoned basis for the scores that were given. So quite an interesting case, really shining a light on the moderation process itself. I think what's clear is that the moderation process should involve a very clear discussion of the evaluator's scores, and the audit trail remains very important. So really important that as part of your consensus process, your individual evaluators have good notes to justify the scores that they've awarded. And also the moderation notes are also comprehensive and make clear whether the evaluators were happy to move their scores up or down, and the reasons for doing so. So an important reminder that the court will look quite closely at the actual process. I think in some of the witness statements and evidence provided by the authority, I think one of the justifications was, well, we've always done it this way, and authorities always do it this way. Excuse me, but that the court expressly said that doesn't make it okay. It's not a justification. So that's all I wanted to say on that case. A quick romp through that first case. We have got a separate webinar on evaluation where we go through some of those points in a bit more detail, so well worth having a look at that. I will now hand over for question 2.
Thanks, Shailee. It's very interesting being on this side of the camera for these sessions. I am going to speak about Braceurself, another fantastically named and very punny company name. If we move to the next slide, Braceurself is an orthodontics company. NHS in this case relates to a procurement for orthodontic services run by NHS England. It is a classic tale of 2 bids and a very close final score turning on the evaluation of whether one question should have been scored 3 or scored a 4. Amongst other points which were dismissed, the court was asked to consider whether there had been a manifest error made by evaluators during the evaluation process. So this is where I'll pick up on the point that Shailee has moved over in the Bromcom case to do with manifest error. To comply with the specification, bidders were required to ensure access for disabled patients in line with the Equality Act. Now, Braceurself site was on the first floor with no lift, meaning that it was for them to explain their proposed solution in their tender response for disabled access via the stairway. They described providing a stair climber, specifically an S-Max cellar stair climber, which takes the patient in their wheelchair up the stairs. The notes of the moderation meeting, however, show evaluators referring to a fixed stair lift. It's a very different solution which requires patients to be transferred from their wheelchair to the lift and back to the wheelchair again once upstairs. Now, in that moderation meeting, 2 of the 3 evaluators who had initially scored a response of 4 changed their score to agree a consensus of 3, scoring that question down on the basis that the solution had limited accessibility. And those notes reflect this conversation and that was included in the feedback going back to bidders. Thank you. Now, generally, the courts will not interfere with an evaluation or with the evaluator's margin of discretion in making their evaluation decisions. It's a high bar for the courts to step in, the exception being where there is a breach of the procurement principles or where there is a manifest error. That is, where a score has been awarded that is obviously wrong or incapable of explanation. In this case, the court considered that the evaluators had simply made a mistake in understanding the proposal, leading to their fundamentally misunderstanding the bid and resulting in that evaluation being assessed on a factually incorrect basis. Braceurself had given the name of the stair climber. They'd given a copy of the quote for the stair climber, meaning in the judge's view that it would have taken a matter of moments to confirm the solution proposed was not a fixed stair lift, but a stair climber. And had it not been for that misunderstanding around the means of access, Braceurself would have scored a 4, which in turn would have, and we've seen this so many times, would have increased the score by 2.5%, thereby winning the contract by a margin of just 0.25%. So it really did turn on whether or not the evaluators understood properly the means of access and factually the response provided by the bidder. And here is my terrible pun, elevating your evaluation. Barring that one mistake and by stark comparison to other evaluations that reached the TCC, the court was generally complimentary about the process. It's a somewhat unusual situation to be in. The process was in many respects unremarkable. I think we can all aspire to our procurements being unremarkable and not reaching the courts. And in particular, the judge was generally impressed by the careful way in which evaluators had tried to carry out their functions. And that broadly well-run procurement contributed to damages not being awarded despite a finding of manifest error. So what examples of good practice does this case give us? It is essential to ensure clear and robust procedures are in place for scoring and moderation. That moderations don't need to be exhaustive or verbatim, but must be sufficient to allow the bidder and the court to understand how the evaluators have reached their decisions, sometimes years later. That it's acceptable to use different evaluators for different questions, reflecting the evaluator's expertise. That it's important to ensure evaluators fully understand the service requirement, and it is critical to ensure that all evaluators properly understand the bid response. If there is any uncertainty, then they may want to consider whether it is appropriate to clarify that in some way. Now, in the interest of time, I flagrantly skipped over the issue of the damages case arising from the manifest error. There were none on the basis that the manifest error did not meet the threshold for being sufficiently serious, but I will close by saying that permission was granted to appeal that judgment, so brace yourself for another update in due course.
Oh dear. Thanks, Vic. So I'm going to talk about question 3 or lesson 3, which is all to do with framework agreements. Now, you'll be aware that framework agreements are sort of an umbrella contract, which allows sort of future call-off contracts to be awarded under it. So procurement is run, which may have a sort of a number of suppliers on it for the framework agreement, and then authorities are able to either directly award from that contract, from that framework agreement, or indeed run a further mini competition amongst those suppliers on the framework agreement. But this case was all to do with the call-off contract itself and the way that the call-off contract was awarded to the supplier. Just a bit of context to that case. So as I've said, there are 2 lawful routes of calling off from a framework agreement, and Regulation 33 is the one to go to when trying to work out the rules to do with direct awards and mini competitions, and we have a separate webinar on frameworks as well. The other important point is that the principles set out in Regulation 18 will apply when calling off from a framework agreement. So those are the what we used to call the general treaty principles: transparency, equal treatment, and non-discrimination. So important to keep those in mind when you are calling off from a framework agreement. If we could just move on to the next slide, I'll talk a little bit about the facts of this case. So in this case, there were 3 NHS organisations, now called ICBs, who were procuring a communication system within the NHS, and they joined together to jointly procure a system. There were 3 companies that were invited to give presentations. The presentations were marked against criteria, but actually it transpired that the bidders didn't actually know, or the suppliers didn't know, that their performance was being marked at all, regardless of where, they didn't even know there was a scoring system in place either. And then after that event, information was provided to Synapsys, which would potentially have shown to have helped Synapsys win that contract. After that, the board sort of found a framework agreement and purported to run a mini competition under the framework agreement, but curiously, only Synapsys were invited to tender. It was no surprise that Synapsys were then awarded the contract. Consultant Connect then brought a claim on the basis that this was an illegal direct award. If we could just move on to the next slide. An interesting case, because the court, one of the points for the court to consider was whether Consultant Connect could sort of bring a claim at all, because they weren't a supplier on the framework, and the court there found that not being on a framework wasn't an absolute bar to bringing a claim. Here it was pretty much central to the breach that was alleged, because use of this particular framework had been done inappropriately to favour one particular supplier. The court did hold that sort of ultimately the use of that framework was a breach, because they'd effectively sort of directly awarded the contract. The mini competition breached Regulation 33. Only one supplier was invited to tender. The requirements were tailored, as it says on the slide, to meet the requirements of that bidder, and also the pricing structure didn't match what was set out in the framework agreement. So lots of things wrong with the way in which the mini competition was run. There was also, as an aside, a conflict of interest that was identified contrary to Regulation 24. Now, this was probably a remarkable case in that a declaration of ineffectiveness was not granted. That's one of the remedies that is available when you are calling off from a framework agreement, but the court did make a contract shortening order to enable the authorities to run a proper procurement. A financial penalty was also imposed on each of the ICBs, ranging from £4,000 to £10,000. Yes, so I think that was sort of the key element of the case, was all to do with the fact that the authorities didn't really follow the process set out in the framework agreement, and there were lots of questions around whether that framework was suitable in the first place. So just thinking about takeaways, what can we learn from this case? It's really, I think sometimes there is a tendency for authorities to, once they've identified the correct framework, are sort of satisfied that they've complied with their obligations under the procurement rules. And I think this case serves as a good reminder that it's important to be clear that you're selecting the right framework for the right reasons. If you are running a mini competition, it's important to invite all capable suppliers on the framework to take part. And that may well depend on the rules in the framework agreement. So there may well be rules around sort of capability, etc., and processes that you can go through. You must comply with the principles of equal treatment, non-discrimination and transparency throughout. And if you do want to use presentations, it's really important to think about how you do those compliantly and transparently, in a way that is still objective, and doesn't sort of breach those principles. So that's all I was going to say on Consultant Connect. I think we're now going to move on to automatic suspension.
Thanks, Shailee. Yes, so automatic suspensions, and this is the National Lottery case, as I think of it. And the reason it's an interesting case is that it illustrates to us how a court goes about addressing this question. Should it maintain an automatic suspension of a contract award, or should it lift it? So just a quick reminder on this slide, what is an automatic suspension? It's a procurement law specific remedy, and it's provided for in the procurement regulations. And essentially, if at any point prior to contract signature, a claimant issues a formal claim in the High Court, the award process is automatically suspended. The contract can't be signed or implemented. So obviously a real hiccup and a headache for the contracting authority and the winning bidder. And the suspension will continue until a special hearing before the court, which the authority has to apply for, and where the court then makes its decision of whether to lift or maintain that suspension. And just to get that hearing organised is likely to take at least 6 weeks, or if not longer. So you can see that this can really be a bit of a sort of roadblock in the process to contract award. And at that hearing, obviously the authority will be arguing that the suspension should be lifted, and the claimant will want it to be maintained until there's a full trial on the substantive issue. And that's because the claimant usually wants to prevent contract award so it can continue to have a chance to win the contract. Perhaps the procurement will be rewound or reworked, and it might still have a chance of getting that work. So the courts use something called the American cyanamide test, that's after the case of that name, to sort of guide them as to how to make this decision. First of all, they say, is there some sort of serious underlying issue to be tried here? There usually is. They then look at, as between the parties, where does the balance of convenience lie? And that essentially means who would be most prejudiced if the decision here goes against the way that they would like it to go. And particularly they look at whether financial compensation rather than contract award suspension would do as a compensation for that party. And they also look at the public interest, which is key because obviously these are public contracts that we are thinking about. So in this case, as we all know, Camelot has operated the National Lottery since before the dawn of time, and this was a re-procurement actually under the concession contracts regulations. And a different operator called Orwin won that new contract. And one of the features that helped it to win was that its bid had contributions to good causes. And Camelot, with everything to lose, brought a claim, and the substantive claim was that there were evaluation errors in the evaluation, and the effect of winning that claim suspended the contract award. And also several of Camelot's subcontractors were joined to that claim, which is the legal term, saying that they were also economic operators. They also had a right to claim. So the court then had to apply that test, and sort of in short, the serious issue was clearly a tick. There were clearly some evaluation errors. There was this question about the standing of the subcontractors was an interesting one that the court ought to think about. In terms of adequacy of damages, what's interesting is that the court felt that damages would be adequate for Camelot if the award was allowed to proceed. So although they had lost a massive contract here, they did still have a lot of work elsewhere in the world, and all those Camelot staff would 2p over to Ulwyn in any event. On the other hand, in relation to the authority and Ulwyn, the court felt that damages would not be an adequate remedy. So if the Gambling Commission, who was the authority here, couldn't award the contract, it wouldn't actually be able to exercise some of its statutory functions. And also Ulwyn, if it was not allowed to get on with running the contract, it would reduce the contribution to good causes, which was the very basis upon which that bid was accepted, and potentially lead to financial losses as well, for which damages were not thought to be adequate compensation. And then finally, in terms of the public interest, the court felt that maintaining the suspension was not in the public interest. It would cause delay and reduce contribution to national lottery funds and hence to charities. So I suppose the key takeaway is that this case confirms that it is a very difficult hurdle for claimants to get over, to get that suspension maintained. Almost always the authority is successful in lifting it, largely due to the public interest element. It's not always the case, but I would say most times the authority is successful in having that suspension lifted. And finally, we'll just pass to Victoria just to talk a little bit about limitation periods. Thanks, Vic.
Thanks, Jenny. In this case dealt with a contract for computer and information technology services connected to a police surveillance room. Given the subject matter of the contract, the Defence and Security Public Contracts Regulations 2011, I will struggle with the acronym, but DSPCR rather than the PCR apply, but the messages are applicable across the procurement regime. The DSPCR provides an exemption where contracts for the purposes of intelligence services may be exempted from the regulations. And in a scenario familiar to others applying exemptions from the procurement regs, the Police and Digital Service issued their document stating the procurement was exempt from, but maintaining a familiar structure to those regulations. If we move to the next slide, please, thanks. In April 2021, Accession was unsuccessful in its bid and claimed various breaches of the DSPCR, including rules on transparency and abnormally low bids in reference to the successful bidder. It received the procurement documents in October 2020, which gave notice of the reliance on that exemption, which, if it were considered to apply, would mean the PDS would not be in breach of the DSPCR. It's familiar territory to us all that procurement challenges must be brought within 30 days from the date the claimant first knew or ought to have known that grounds for starting the proceedings had arisen. But when in this situation did the clock start? Was that in October 2020 when Accession became aware that the exemption was being relied on, and in which case any claims were time barred? Or in April 2021 when the potential breach crystallised and the outcome was announced? Answers on a postcard while we move to the next slide. And in what might be somewhat unwelcome news to those who regularly rely on exemptions, the court clarified that time starts when the breach occurs and giving the claimant the knowledge of the breach based on the conduct of the contracting authority. Since it wasn't possible at the time of the procurement documents for the claimant to know what those breaches would be or which elements of the regulations wouldn't be followed. And as such, claims that were brought by accession within 30 days of the contract announcement, not the issue of the procurement documents, were not time barred. And while the court was satisfied in this occasion that the exemption was properly applied, this case provides helpful guidance to contracting authorities applying procurement exemptions and raises the importance of statements around proposed conduct of a process that voluntarily applies the procurement regulations, which I think will be a risk to be more particularly managed in future exempted contracts. Staying very quickly on that topic, the principle of time running from when the knowledge of the nature of the breach was reaffirmed in the case earlier this month. In Evaluators, the claimant was found to have brought their claim in time, despite referring to having been minded to bring proceedings that it may be forced to bring protectively issue if it were not provided with information in respect of why its contract was terminated and awarded to another supplier. The court found that it wasn't until that information was forthcoming, giving Evaluators the knowledge of the reasons for the termination, that the 30-day time limitation started. And I will stop there, conscious of time.
Yeah. Brilliant, thank you, Vic. Yeah, so it's 10:30, so it's probably time for us to wrap up and let you continue with your day. There's a link to all the cases there, including Evaluators that Victoria mentioned just then. There's also been a very recent case on substantial modifications under Reg 72. That's James Waste Management. We haven't had time to talk about that today, but do have a look at that. We've got a blog post on that, a really helpful case for everybody interested in procurement law. So yes, thanks very much everyone for joining us. Do look out for our follow-up email, so that will have the recording, the slides, and a response to the questions that I've seen have come in. There should be a feedback form at the end. It would be really grateful if you could complete that. And so finally, just to say thank you very much to you all for attending. Hope you found it useful, and to see you again at our next webinar, which I think will be in September, when we hope the procurement bill will have royal assent, and we will begin our journey of looking at how that's going to change the whole world for all of us procurement lawyers. So thank you all for joining us, and have a lovely day. Thank you.